To introduce our afternoon speaker, Helen Tugendhat, who's the program coordinator at the Environmental Governance at Forest Peoples Program. Helen, can you hear us?
Yep, I can hear you well. You can hear me all right?
Yes, we can. Thank you.
I'm just gonna share some slides. I'll just see if that works. Okay, is that visible to everyone?
Yes, it is. Thanks.
Perfect. All right, I'm going to stop my video just while I go through these slides, and then I'll turn it back on at the end if there's any questions or comments that people would like to make. So I wanted to say, first of all, thank you for the opportunity to speak today. Thank you in particular to the University of Arizona for putting together this symposium, and for Professor Williams and Melanie for inviting me to speak and to share some thoughts. I've never followed an Indigibot before, so it's a slightly intimidating speaking slot to take, but I'll do the best I can. I wanted to recognise that the discussions and the presentations over the last day and a half have provided a really rich and really nuanced and quite a lot of really difficult insights into the history and much of the current practice of conservation. And I'm really honoured to be part of the conversation about how this plays out in the world that we're in. Before I start with the comments that I wanted to share, I just wanted to introduce a little bit about where I come from, so you know the perspective that I'm bringing to bear on these issues. As was mentioned, I work for an organisation called the Forest Peoples Program. It's a land rights and a human rights organisation, and we work almost exclusively or primarily with Indigenous peoples around the tropical forest belt. Within FPP, we've got quite a few programs of work that we use to deliver on our partnerships with Indigenous peoples and with communities. And I coordinate one of those programs, and I just wanted to say a few words about that program. It's called the Environmental Governance Program, and it's the area of work that we use to support developing or enhancing or evolving territorial governance and management strategies with our partners, with Indigenous organisations. And that includes conservation and sustainable use and many other elements of maintaining spiritual and cultural and physical connection to territories and places. The programme is also the one in which our work on conservation and human rights sits. And I wanted to say a little bit about conservation and human rights and how we understand that they connect to each other. So we work with partner organisations and with Indigenous peoples in many places to push for recognition and for respect of the lifeways and the strategies that they have generationally been using to manage their territories. That includes the contributions that they make to stem biodiversity loss and to mitigating changing climate, but sits on the foundation of supporting self-determination. In addition to that, we also work extensively with partners who have been repeatedly or generationally found their rights violated by the practice of externally imposed conservation. And I use the word generationally here with pretty deliberate intent. So some of our partners, like the Batwa, who we work with in Uganda, have very few living elders who remember or knew the territories from which they were expelled. So having given you a little bit of a background of sort of where I come from, I wanted to introduce sort of the thoughts that I wanted to make. I've been asked to give some reflections on the pretty daunting topic of decolonising conservation and protecting biodiversity using a human rights-based approach, as you can see on the slide here. So this imperative, hold on, I can't move my slides. There we go. This imperative to decolonise conservation is really clear. Building on the insights of work by the former Special Rapporteur, Vicky Talikorpis, with the Cornered by Protected Areas report, and the reports of Francisco that we've already heard talked about quite extensively yesterday and today, and also building on work of organisations like the Indigenous Peoples Rights International and the database of criminalisation that they've created, and obviously the work of the Protected Areas and Indigenous Peoples Program here at the University of Arizona. There is real attention to the need to address and change practice. So one of the questions is, what does that mean? What does decolonization mean? And I've put this quote up on the screen. I hope it's big enough for you guys to see, to illustrate that the history of conservation, and this is well known to everyone in the room and online, the history of conservation is deeply entwined with the history and the present of the impacts of colonization. The language of colonial ideals about values, about who's got the right to be where, who's got the power to decide what these things are. This is language which it's really important not to forget. And the words that you can see up on this screen were spoken not that long ago. There are people alive today who were alive when these words were spoken. And echoes of these words are still spoken today, albeit often a little more quietly now. So these are shocking words. They're really shocking, and they're made more shocking by the actions we all saw last year, and the actions that were threatened to happen again with the Maasai evictions from Loliondo in Tanzania. These aren't stories that sit in the past, and I wanted to make a particular point about this, about actions that are sometimes referred to as historic injustices. Just because an action took place in history, it doesn't mean that it doesn't cause ongoing injustices. To call the challenges that face the Batwa in Uganda now historic renders all of the current injustices they face invisible. And I wanted to make this point because it's too often overlooked by those who talk about grievance mechanisms and redress. The acts of the past have a real and present impact, and it can't be forgotten. It can't be turned into a clean slate so that people can turn and move on. But I also wanted to recognise that conservation is not only the colonial words and practices imposed from outside. Conservation, when sort of broadly understood as actions that serve to protect or maintain or manage natural resources, is pretty intimately connected to the systems of rights and responsibilities that humans have always asserted and recognised. And this is true in customary law, as well as in national, regional and international laws. I wanted to share this quote, also from East Africa, from an Indigenous gathering in a place called Labot in Kenya. I wanted to highlight in particular the final sentence: the only sustainable way of caring for our environment is through belonging. There are many of the Indigenous partners that we work with who assert alternatives to the form of conservation that they have seen and that they've felt cause untold harm. Giving these alternatives voices, and I want to share another quote here, as Pasang does here, this is part, in my view, of the job of decolonisation. It's the assertion and the defending of alternatives that are self-determined, that are self-defined, and that are drawn from generational examples. And reflecting on our role as the Forest Peoples Programme and on the roles of many international organisations and others that seek to support Indigenous peoples is to figure out how best we can be allies in asserting what these alternatives are in the places where they need to be seen and where they need to be heard. So I've been asked to talk a little bit about how a human rights-based approach might contribute to this work or to advance this work in some way. So I wanted to start with, what is this term? Where does it come from? What does it mean? It's used often as an acronym, and if you scratch the surface, people are a bit hazy about what sits behind it. It's a relatively simple concept, but has a very complicated and nuanced process of implementation and use. Human rights-based approaches as a sort of theoretical idea were first developed in the context of sort of development thinking. And then it was applied across into sort of public service provision, looking at things like education and health services. And it's only really quite recently that a human rights-based approach has been talked about in the context of biodiversity action, biodiversity planning, and practices. And it's through that application into biodiversity action that it is then talked about in the context of conservation practices. In these contexts, in contexts like biodiversity planning and action, or contexts like conservation, a human rights-based approach has particular resonance because any action which is taken in a landscape is inextricably linked to the rights to lands, territories, and resources, and through those into the myriad of other rights that for Indigenous peoples are tied to those underpinning rights to lands and places. This includes rights like the right to cultural survival, to the transmission of knowledge, and to the recreation of generational relationships to place. So simply stated, as you see on the screen in front of you here, it's not complicated, but a human rights-based approach requires the identification of everyone who has rights in a particular situation, and then active planning and work to ensure that those rights aren't violated or disturbed or infringed in any way. But it's also further than that. A human rights-based approach requires that if there are opportunities to advance rights or to promote them, that those opportunities need to be taken in the context of the actions that are being proposed. So as I said before, conservation-related or biodiversity-related action is particularly relevant for Indigenous peoples in this, because the rights that are most likely to be impacted in some way are rights to territories, lands, and resources. And I did want to emphasize here that rights to lands, territories, and resources are, of course, only one perspective into the relationships that Indigenous peoples have with their lands and resources, and they link across into multitudes of other rights. I wanted to note, and this has already been mentioned today, and I think it was probably mentioned yesterday as well, but I wanted to talk a little bit about an instrument or an agreement that has recently been adopted that insists on a human rights-based approach. This is the Global Biodiversity Framework, the Kunming-Montreal Global Biodiversity Framework. This commits, it's interesting the language that it commits to. It commits not only to a human rights-based approach, as you can see here, it also talks about intergenerational equity and the responsibility to future generations of the decisions that are made today. And it also recognises very directly and in quite lengthy text the roles and contributions of Indigenous peoples, and that its implementation must ensure their rights. It also talks about environmental human rights defenders, about access to justice, and about protection of rights defenders. It's also the framework where a commitment has been made, and again, this has been mentioned a number of times and is very familiar to everybody here. This is the framework that holds the commitment to massively increase the area of land and of fresh waters and of oceans which are under some form of protection or conserved status. This target commits to an increase to 30% of lands, 30% of oceans, and it commits to this in 6 years and before 2030. And if we put this into context, this number was mentioned yesterday by Shankar as well. In the databases held by the UN, 17.3% of lands are currently recognised as being under some form of protected or conserved status, and about 8% of oceans. So this is a near doubling in 6 years. This target was obviously hotly contested and argued for many reasons. And one of those reasons, a very significant reason, is the serious risks posed to Indigenous peoples and to many peoples and communities who have and hold and maintain close ties to lands and resources, but who live in countries where these rights are not recognised, or where they're recognised in limited ways, or where they're recognised but not implemented or realised. These fears are entirely justified, and that has been ably demonstrated by many of the speakers who've shared stories and experiences and histories during this symposium. There are simply too many countries and too many contexts in which the rights of Indigenous peoples are not respected under national law. One of the responses to the emergence of this target, which emerged some years well before the agreement was adopted, was that a group of Indigenous advocates, a large group of Indigenous advocates, engaged in the negotiations with governments in order to change. Sorry, I just lost my place for a second. In order to change the target, and in particular to reduce the risk of violations, so to change the language in a way that would reflect in some way the histories and the impacts of conservation that they knew and that their peoples and their elders had felt. And it doesn't in the end, it's an intergovernmental agreement. So these are not the words that would have been drafted certainly by human rights advocates or by Indigenous advocates. But I think it's very important to see the two key elements that were brought into the target as a result of the long and multi-year work of Indigenous advocates. So there's two key ones that I wanted to highlight. One is that the 30%, this 30% target, needs to include recognising Indigenous and traditional territories, not as protected areas necessarily, and not necessarily under any designation determined by others, but they have to be there in the 30%. The other is that all action under Target 3, everything, must recognise and respect the rights of Indigenous peoples and of local communities, including to their traditional territories. So this is, as has been mentioned, it's an intergovernmental agreement. It's got a lot in it, and it's got little or no real enforcement mechanism outside of reporting duties. So the language that we're looking at here, it's not going to change practice on the ground particularly quickly. May not change it at all. But it does reflect that because of decades of work, the roles of Indigenous peoples in ensuring conservation outcomes because of the ways of living that they have. And it reflects that there's really widespread knowledge of the risks that are inherent in expanding protected and conserved areas. So Suhas spoke about this earlier today on his panel and mentioned that the very real question of what on earth governments are going to do with this agreement remains to be seen. It has to be tracked, it has to be followed up. So we have an agreement here that has a few useful elements that we can pick up and use in different ways. It's an agreement that insists on the use of a human rights-based approach, and it also recognises Indigenous peoples' alternatives to mainstream conservation. And it recognises that conservation has historically and in too many places continues today to violate the rights of Indigenous peoples. So I'd like to return from talking about the global biodiversity framework to coming back to a human rights-based approach for a minute, because I wanted to reflect a little bit on how it looks in practice. So a human rights-based approach is nuanced and tailored according to a lot of different considerations in a given place. It has to reflect on the history and on the nature of rights in a given landscape. But there's a dimension of the human rights-based approach which is often not recognised, and I wanted to highlight it because it's really important for how a human rights-based approach might play out and how we understand what it requires. And that is the who in the question. Who is it that is proposing this new status of a protected area as protected or as protected or conserved, and what laws are they doing that under? If the proposals emerging from external actors, whether that's government agencies or NGOs or others, then that requires a new set of considerations. If the proposal is sui generis, if it's emerging from Indigenous peoples themselves and they're seeking technical or financial or political support to enable it, then the considerations need to be different. So this is the difference for me between self-determined and externally proposed. Both are possible in the expansion of areas that are understood to be conserved, but the vast majority of resources, of financial resources that are dedicated to biodiversity protection, go to the latter. They go to externally proposed conservation. We've heard a lot about financing during this symposium, about the flow of money and resources, and I'm going to return to that topic again because I agree with many previous speakers that it's a really important topic and a really important lever in terms of understanding how we can support and advance human rights protection. So the final question I wanted to talk to before I stop and ask if anybody's got any questions or reflections is what can be done. So it's obvious to me and obvious to many others that human rights violations are most acute where rights are unrecognised or where they're recognised only in very limited ways. And this, for me, means that it is most critical that we support Indigenous peoples whenever they're involved in national level struggles for reform of the laws or the policies that don't reflect or protect their rights. But it's also the case that we as international allies have some access to other levers that we can use in tandem or in concert with Indigenous partners. And it's these levers that I wanted to talk about a little bit now before I stop. The first one is financing. So we heard from Knox about human rights norms, which have been identified through a long process by Knox and many of his colleagues. And they've been identified not only for conservation agencies, but also for conservation financiers. So understanding and highlighting the responsibility of these funders for actions taken by those who use their funds is an excellent lever. It spreads out identification of duty bearers, it spreads out or broadens understanding of who has responsibility to act, to respect human rights, and in some cases to promote or even fulfill human rights. These principles can and should, in my view, be adapted for use also in the growing area of biodiversity credits and the financialization of nature. These so-called nature markets are nascent when compared with carbon markets, and we had some discussion about carbon markets yesterday and the impact that they've already had. But the application of same or similar market rules to the destruction or the protection of nature opens up huge areas of concern. And Indigenous peoples representatives and organisations in many places are already in the thick of addressing this. Many people during this symposium have spoken about the importance of financing and addressing the responsibility of donors. And this is really important work, but I also wanted to point to the complexity and the diversity of the kind of financing that comes through for conservation and biodiversity. Right now, as this symposium is being held, there is a CBD meeting happening in Colombia where the strategy for raising funding to finance the global biodiversity plan is taking place. And the headline areas that they're talking about, with Indigenous advocates present talking about the need for rights-based approach to financing, they're looking at international public financing. So that's the Global Environment Facility, institutions like that. They're talking about domestic public budgets, so taxes and things like that. They're talking about private funding, and that includes private philanthropy and gifting. And it also includes financial instruments and markets, and how to control or encourage, to use the words of the CBD, an increase in innovative financial mechanisms to bring private investment into biodiversity. These are massive areas of debate and discussion. Each one of these is incredibly detailed and difficult. And they are also, as the fifth area of negotiation, talking about non-market approaches, which are called Mother Earth-centric actions in the framework. And it may not come as a surprise to people in this room and listening that this last bucket of Mother Earth-centric actions gets the least attention in discussions around what that strategy might be. But these are big and complex and difficult conversations. And as international allies, we need to be allies in this as well, in talking about how this financing works. The second lever that I wanted to talk about quickly is international law. And it was, I really enjoyed the early talks yesterday and the sort of reflection on international law and its emergence as a tool of oppression and a justification for land appropriation, and also for the growth of empire. International law, particularly the Declaration on the Rights of Indigenous Peoples, now stands as a framework that recognises the rights of Indigenous peoples, and that recognition is in advance of the recognition that's afforded in most of the nation states that we live within. The use of international law is complicated, and this has been mentioned in this room as well. It can be slow, it can be very difficult to enforce, and it can be very challenging to access. But there is one piece of international law that I wanted to flag, as it may have some leverage for driving behavioural change in some places, and that is the World Heritage Convention. One of the speakers who's going to be speaking after me in this symposium has been engaged in advancing the use of this convention for a long time, to highlight the chasms that can exist and often do exist between international laws and standards on the one hand, and then what is actually practiced on the ground on the other. The very last lever that I wanted to talk about is advancing Indigenous alternatives. And investing, there we go, and investing in technical and political and financial support into the self-determined governance of territories. And I think this type of support, this engaged and direct technical support, is often not given the attention that it's deserved as well. And we need to be allies in this third area of action. So thank you. And I will stop sharing my screen. And if there are any questions or comments or reflections, I'd love to hear them.